Greetings everyone, I am Devranjan Singh Shekhawat, pursuing BB LLB Honours, second year and intern at ubAdvocate. Today I am here to discuss about the recent complications that arose due to the affidavit filed by the Government of India regarding the same-sex marriages before the Delhi High Court. In the February 2021, the Government of India filed an affidavit before the bench of Chief Justice D.N. Patel and Justice Pratik Jalan before the Honorable Delhi High Court in the case of Abhijit Iyer and others versus Union of India. The appropriation of marriage was sidelined on 25th of October when the Council for the Government of India told that marriage is possible between only heterosexual couples, that is, a man and a woman. Such an affidavit, which violates the fundamental rights of the communities, suffered mass protests from the youth communities in the Delhi. There were mass protests organized by the students of Delhi University and other university for the setting aside of affidavit and granting the rights that are available to the communities, especially the LGBT communities, as if in this case now. It is to be noted that in the landmark case of Devranjan Singh Shekhawat, the Supreme Court decriminalized the Section 377 of IPC, providing consensual relationships to the LGBTQ communities. Now, the affidavit of the government is against the violation of the rights that were envisaged to the LGBTQ communities in the case of Devranjan Singh Shekhawat. The counsel for the center stated that decriminalizing the Section 377 of IPC does not provide the right to a marriage to LGBTQ communities. It only provides the right of consensual companionship to LGBTQ communities. Government of India, being a public authority, does not have the right to violate the fundamental rights of the citizens and the communities of the India as per the Indian Constitution. As of now, there are no legal provisions supporting the marriage between LGBTQ communities. The Special Marriage Act and the Foreign Marriage Act do not also have the provisions for the marriage between LGBTQ communities as of now. The Hindu Marriage Act does not differentiate between homosexual and heterosexual marriages. Any marriage which is solemnized between two Hindus is accepted as a legal and a valid marriage under the Hindu Marriage Act. So why not accept the marriage of two LGBTQ communities of a Hindu religion as a valid one? Looking at the global developments on the theme, recently the country named Cuba drafted a new family code on September 15, which has received great applause from the LGBTQ activists. The new family code defines the marriage as voluntary union of two people, as opposed to the previous definition of between a man and a woman. Such an act is something that is needed in the Indian legislation to support the marriage between LGBTQ communities, to uphold their rights and not violate any. The legislation need to work on the upliftment of rights and not violate any. It is time when legislation should draft a new family code or make amendments in the previous codes to support these communities. The communities are also part of India and also have rights that are envisaged in the Constitution. With this, I would like to conclude the discussion. Thank you.